Should a local prosecutor who, of necessity, works hand in glove with the local police department be the person to bring a case before the grand jury if indeed the case involves the potential prosecution of a police officer? Or should there be an independent prosecutor who can look at the case and is not necessarily beholden to the particular police department?
The first recorded case of a grand jury is believed to be an act of English King Henry II in the year 1166. The Fifth Amendment of the U.S. Constitution, part of the original Bill of Rights, provides for the presentment or indictment of a grand jury. But in the wake of Ferguson and Staten Island, there are those who believe the time has passed to reconsider how these juries are used and if they are truly honest and effective. Let's welcome to MidPoint, a commissioned officer in the United States Navy and a graduate of Harvard Law School. He has previously worked with the Department of Justice's Office of International Affairs and Counterterrorism Section. And he's currently on a 2-year active duty deferral in order to serve as a judicial law clerk. He has asked us to note that the views expressed are his own and do not reflect those of the U.S. Navy, the Department of Defense, or any particular court. Let us welcome Joshua Fiveson into the show today. Joshua, good to see you again.
Great to see you again. Thanks for having me.
That is the main point that we need to get to. Have we reached the point where grand juries are simply wasteful and pointless?
Well, you raised a really interesting point in your introduction. The grand jury dates as far back as Henry II, and if we're going to be honest, that's pretty far back. But even then, it had questionable foundation. When first created, the grand jury was just an arm of the king and just another means by which they could bring these overly zealous prosecutions. And it wasn't until the College and Shaftesbury cases where the grand jury first took on this role as a bulwark against oppression and overly zealous prosecution. But even those cases didn't exactly turn out the way one would think. When it came to College, the first grand jury didn't indict, surprisingly. The king just brought another one, got the indictment, and he was ultimately executed. And Shaftesbury, after the first indictment failed to bring a true bill, as they call it, he had to flee the country in order to avoid prosecution. And in both of those cases, these individuals were technically guilty under the current interpretation of the crimes with which they were charged. So if you look at the historical underpinnings, this was a use of the grand jury system that didn't necessarily reflect the law. It reflected a political motivation.
Have we not gotten to a point, though, Joshua? I only got a couple of minutes left. I want to make sure we get everything in here, though. Have we reached a point, though, where it is only invariably what the prosecutor wants, and that's what has to be changed, whether it's a special prosecutor or some other form of trying to find out the truth in a dispassionate way?
Well, sadly, that really is the case. You know, there's the classic tenet that a grand jury can indict a ham sandwich. And you really have to look at the framework. A prosecutor doesn't need to present legally valid evidence. They can provide evidence that has been unconstitutionally collected. They don't have to, depending on where it is, of course, I'm speaking to federal grand juries, but states have their own systems. They don't have to present any testimony from the defendant. It's conducted in secrecy. There are no review mechanisms. So at the end of the day, you're asking a group of lay people to make a decision that is based on a prosecutor's already demonstrable intent to bring charges. So yes, it's swayed by the prosecutor.
I only got about 40 seconds left here. The New York State Attorney General's office today has asked the governor to authorize them to investigate the deaths at the hands of police following everything that happened in Staten Island. Is that where we're heading right now, that the Attorney General of the states needs to be one that takes this over and then decides to get it to a jury, blow out the grand jury altogether?
Well, see, that's just but one avenue. As you know, for grand juries, multiple indictments can be brought. Jeopardy, in the constitutional sense, doesn't attach from an indictment, so multiple indictments can be brought. And secondarily, this is a question of justice. The grand jury represents a procedural safeguard, and right now, I don't think we can say that there's public confidence in the system. So whether or not something else needs to be done is not the question, but what is the next step and what has to be done, or what will be done, rather, is the real question.
It's that safeguard issue, I think, that we're getting down to right now that a lot of people want to discuss. Unfortunately, we're out of time. We're going to have to take that up another time because now we've opened up another Pandora's box right here on things that need to be done in the judicial system as well. Joshua Fiveson, always a pleasure, my friend. Thanks so much for joining us.
Thank you for having me again.
All right, break, and we return with changing rules for cops in the 21st century, as detailed by the police commissioner from one of America's largest cities. This is all part of the overall discussion we have in America now due to Ferguson and Staten Island and so many more. Stay with us. MidPoint will continue.